From the supplementary list, next is at 10:30, item 2, second appeal 26/1998.
Next results. This was list for today on IA. Now in this case, you may kindly see the IA which has been filed. That is IA number 701.
कौन सा वाला?
Second appeal 216 आया था.
नहीं सप्लीमेंट्री का
वही तो बोले था मेरा है
सप्लीमेंट्री का टू मेरा है.
सप्लीमेंट्री नहीं होगा मतलब टू होगा लेकिन उसमें
एक पाठक है।
हाँ
10:30 लिखा हुआ मेरा केस लिखा हुआ.
आपका केस भी
10:30 लिखा हुआ इसलिए.
लिखा हुआ है क्या?
लिस्ट में नहीं है। आइटम 2 आप 10:30 नहीं है, आपका है
आप आइटम 2 इसीलिए
सेकंड
कोई बात नहीं, उनका हो जाए.
छोटा सा मैटर है आपका।
नहीं हमरा सब्स्टिट्यूशन पर वो जो सुन रहे थे
ठीक है।
उसमें हुआ था कि इनका अगर सुनना चाहते
नहीं इनका आधा सुना हुआ है, आप इनका सुनते हैं। आप ऑर्डर्स का केस है ना 4 बजे।
नहीं कोई बात नहीं, हम 10:30 सोच के
हाँ नहीं कोई बात नहीं,
हम भी
आप 4 बजे आ जाइए, 4 बजे।
Mr. Abdul analysis on Lexi code number 20.
No, it's
Yes,
a password matter. You let them add.
Yes, sir.
थर्टीन तो अभी बैठा भी नहीं है।
Code 20. He said to continue with the case, he will join.
I would not start from the issue of abatement first, because if that is decided not against the appellant, then not everything goes. So now your lordship has held on 4th last date, note that the case has abated against respondent number 8, but the claim was filed. But in which certain relief were sought for, and that relief is against all the defendants in common. The case of the defendant is that they are claiming through their ancestor, who is Meghlal Kevat. Not all the defendants are claiming through Meghlal Kevat only. Now, not the suit was initially decreed to the Lordship on 2 counts, that is giving me title on basis of deed and on basis of long continuous possession. Appellate court not said it's the deed is in violation of section 46, although decreed the suit on terms of adverse possession. So what we are challenging the appellant here is that a decree in which the suit have been decreed in favor of plaintiff, granting decree of adverse possession against all the defendants in common. So now notice there is a decree against respondent number 8 by the title appellate court, saying that the plaintiff's suit is decreed on ground of adverse possession against respondent number 8, which has attained finality. So now, in view of this, that so far as that judgment of lower appellate court is final against respondent number 8, can my lords, the entire suit would be held to be abated or not? On this principle, your lordship may kindly take. This was not reported, but I got the copy notes from live law. But your lordship may kindly take paragraph 16, because it is the principle of law what we are putting in. There not, I will just inform your lordship that the suit was filed by the plaintiff against 2 defendants claiming declaration of title, recovery of possession. That suit was initially dismissed. The appellate court decreed the suit. The second appeal was filed by the defendant, and in that second appeal, one of the respondents died, and the High Court held that the same has abated, and ultimately dismissed the appeal in total, saying that the entire appeal is abated. The matter went before Supreme Court. Supreme Court also confirmed the judgment of the High Court, saying that appeal has abated. and Supreme Court have dealt. Your Lordship may kindly take para 16, in which one of the judgments have been referred. May I please? May I please? In Ram Swarup versus Munshi, there was a decree of preemption against the defendant appellant who has bought the properties on co-defendant in the suit. One of the appellant died and his legal representative was not brought on record. The issue which fell for consideration was whether the whole appeal abated or the abatement was who are the deceased appellant only. Argument on behalf of the surviving appellant was whatever might be the position as regards to the share to which the deceased appellant was entitled to in the property purchase, the interest of the deceased was distinct and separate from that of other, and that the abatement could, in any event, be only partial and would not affect the continuance of the appeal by surviving appellant, at least as regards their share in the property. To deal with the above argument, this court called for the sale deed by which the appellant had purchased the property. Upon consideration of the sale deed, the court found that it was not a case of sale of any separate item of the property in favor of deceased appellant, but one of the set of properties to be enjoyed by vendees in equal share. Based on that, the 5-judge bench of this court held it is clear law that there can be no partial preemption because preemption is a substitution of the preemptor in place of the vendee, and if the decree in favor of preemptor in respect of the share of the deceased Meher Singh has become final, it is manifest that there would be two conflicting decrees. If the appeal should be allowed, and the decree of preemption insofar as appellant number 225 are concerned is interfered with, where a decree is a joint one and part of the decree has become final by reason of abatement, the entire appeal must be held to be abated. Now next, para 7. Having regard to the aforesaid decision, the law governing determination of the issue as to whether abatement of an appeal or non-substitution of deceased party is partial or whole can be summarized as under. 1. The answer to the question whether the entire appeal abates or it abates partially for the deceased party alone will depend on facts of each case, and therefore no exhaustive statement about the circumstances in which the entire appeal would abate can be made. As a matter of course, courts will not proceed with an appeal toward when the success of the appeal may lead to the court coming to a decision which is in conflict with the decision between the appellant and the deceased respondent, which has become final with respect to the same subject matter between the appellant and the deceased respondent. So, not this, in my humble submission, not covers the issue that so far as decree of the title appellate court is confirmed against respondent number 8, it has become final. Then if your lordship allows this appeal, then it will be a conflicting in nature, because one decree will say plaintiff suit is decreed against respondent number 8, the another decree will say the plaintiff suit is dismissed against other respondent except respondent number 8. So therefore, there will be two conflicting decrees. But one argument which I conceive from the appellant side is that they might say that Ram Prasad Kewat have died, his other legal heirs are already there who are representing, but not so far as respondent 8 is concerned, who is one of the daughters of Ram Prasad Kewat, who was substituted when she was minor, and that substitution was made when the suit was proceeding. So the suit itself, now the suit is of 1992. So we are in 2025. So now it can't be said that she is being represented by her mother, and therefore abatement of respondent number 8 will not affect the suit or the appeal. Here my submission is that once it has been held that it is abated against respondent number 8 and that judgment is final so far as respondent 8 is concerned, then any other order reversing or modifying that order will have a direct bearing on that point. Good
statement.
And ultimately, not in this case also, not the Supreme Court holds that since it has awaited against one, it cannot be segregated because it is a decree it cannot be segregated, it cannot be severed. Because the title of the court judgment is against all the defendants, not against one. And it also takes care of Order 41 Rule 4 notes. So your lordship is aware that in terms of Order 41 Rule 4, if there are not 10 defendants, for example, and if 2 only files an appeal, and that appeal is allowed, then it will be deemed that all these have succeeded, in spite of the fact that they have not preferred an appeal, because it was a joint decree. And therefore, not the Supreme Court also takes into consideration Order 41 Rule 4 series.
Where is Order 41?
Yeah. Where it is. But Order 41 Rule 4, one or several plaintiff or defendant may obtain reversal of whole decree if it proceeds on the ground common to all, where there are more plaintiffs or more defendants than one in a suit, and the decree appealed from proceeds on any ground common to all the plaintiffs or to all the defendants. Any one of the plaintiff or the defendant may appeal from the whole decree, and thereupon the appellate court may reverse or vary the decree in favor of all the plaintiffs or defendants as the case may be. So not even if it is argued that defendant number 8 did not prefer an appeal, but still there is an appeal from the common judgment which is binding upon all the defendants. Then also, in terms of Order 41 Rule 4, if the decree is reversed, it will be held that all the defendants have succeeded.
The estate is represented.
But it is not the state. Therefore, your Lordship, may I kindly see, this I was contemplating that this will come from the appellant side or not a query that the state of Ram Prasad Kevat is being
The original defendant was followed. Ram
Yes,
Prasad.
yes.
And then the minor also died.
Sorry?
The minor died.
Yes.
She was initially substituted. She was
No.
upon the death
Yes.
of her father, she was substituted
She was
at the
substituted.
stage of trial.
Right.
Right?
Yes.
And then later on she expired
Yes.
and she was not promoted.
Yes.
So her state is very much represented.
But whatever interest she had in
The
her, yes.
the entire estate of the original defendant who expired
Yes.
was being represented by mother, by brother, everybody is there.
But same judgment, your Lordship, have just read para 17.2. Your Lordship may also see 17.7. what it says, existence of a joint right as distinguished from tenancy in common is not the criteria of joint or inseparable degree. 17.7. I'm not sure. 17.7, no? Paragraph 17, point number 7. Existence of a joint right as distinguished from tenancy in common is not the criteria of a joint or inseparable decree. The joint character of the decree will take color from the nature of the decree challenged. So not the nature of the decree, what is sought to be challenged.
Nature of the decree is adverse possession.
Adverse possession. So adverse possession decree is against all these defendants. So not if the decree, so far as respondent 8 is concerned,
Adverse possession decree was originally against her father.
but
Right.
adverse.
So adverse possession decree is originally against her father, and at the time of filing the suit,
Yes.
whether the adverse possession has materialized or not is to be seen. It is not something which takes place during the pendency of the suit. Adverse possession on the date of filing of the suit has to be tested. If the adverse possession qua the deceased father
Yes.
stood tested, the suit will relate, the plea of adverse possession will relate from the date of filing of the suit. So her estate is represented as a whole.
Lord, what is coming from Lordship that the date of actual filing of the suit has to be
Yes.
tested
Certainly, so far as adverse possession is
for
concerned.
granting a decree.
Certainly,
But for
granting.
deciding the question of abatement, that once there is a decree and the appeal has abated against any of the defendant, whether that
And therefore, the
Yes.
entire estate
Yes.
stands represented. There was a common written statement filed.
Yes.
Everybody contested the suit in common.
Yes.
There was no conflict, nothing. Right? And subsequently he died, he was substituted. And one of the substituted heirs was not substituted.
Yes. Therefore I say. Therefore I say, Lord.
We'll decide it. I
Yes.
got it.
So this is my submission so far as abatement is concerned.
Yes, thank you. Second appeal number 26 of 1998 written back in R. The learned counsel for the respondents on the point of abatement in connection with respondent number 8 has submitted that though her father was the defendant in the suit and upon his death she being a minor and other children and widow were substituted in the pending suit. But on account of non-substitution of respondent number 8 in the second appeal, the impugned judgment and decree has become final as against her. The learned counsel submits that accordingly, no adverse possession with respect to the suit property can be declared in favor of the appellants and the learned counsel submits that if the point of adverse possession is now decided in favor of the appellant, the decree being non-severable, there will be conflicting decree passed by this court, and therefore the appeal as a whole stands abated. He has referred to the judgment passed by the Honorable Supreme Court in 2025 live law written back at SC 728, paragraph 17, and has submitted that the case is covered by paragraph 17 written back at 2. It is also submitted that existence of a joint right as distinguished from tenancy in common is not a criteria of a joint or severable or inseparable decree by referring to paragraph 17 within bracket 7 of the state judgment. Now you tell us one thing. Suit was filed by this Ratan Lal.
Yes, please.
Correct?
Yes.
It was decreed.
Yes.
Appellate court sustained the decree so far as adverse possession is
But
concerned.
the trial court decreed the suit, granting me title and on basis of continuity of possession, not on adverse possession.
Title and continuity.
Because title and adverse possession can't go together.
Appellate court
Appellate court not said that your deed is in violation of section 46. So title was not negated on that. But appellate court not granted me a decree on basis of adverse possession.
title negated, granted decree on the basis of adverse
Adverse.
possession. Okay. Right. Now, the decree which has been granted,
Yes.
so far as adverse possession is concerned, is under challenge. And the person who has died was the co-defendant in the suit. So,
So therefore, sir,
is the co-defendant in the suit?
is the co-defendant? Yes.
Yes.
He was a co-defendant.
Yes. And if the appellant wins,
Yes.
she naturally wins.
Therefore I say. Therefore I say.
So therefore,
Yes.
if the appellant wins,
Yes.
she naturally wins automatically.
She naturally wins.
Yes.
So here will be a conflict that if respondent number 8, the judgment has abated and it has attained finality so far as title appellate court judgment is confirmed, which says that the plaintiff's suit is decreed on ground of adverse possession
Yes.
against respondent number 8. And
Not against respondent number 8.
But-
It is against respondent number 1. No, sorry. Yes.
all the respondents,
All the
including 8,
respondents.
but here not on the point of abatement. Once the judgment of appellate court, first appellate court, is confirmed on the ground of abatement against respondent number 8 alone, because here I say that the appeal by other defendant and so far as other respondent is concerned is in continuity, it is under hearing, but so far as after holding.
You see,
that
if the appeal is dismissed,
Yes,
right?
yes.
Then under such circumstances, there
There will be no conflict.
will be no
Because
conflict.
there will be a judgment confirming title appellate court
There will
judgment.
be no conflict.
Yes.
Right?
But
If the appeal is allowed,
yes, if the
if the appeal is allowed,
yes,
then under such circumstances, the position of adverse possession will go.
exactly.
Yes.
If the appeal is allowed and the question of adverse possession is answered in favor of the appellate, but let me assume this for argument, then Lords, there will be a decree which says that the plaintiff's suit cannot be decreed on ground of adverse possession. This the Lordship will have to hold because the appeal is allowed. Then there will be a situation where, so far as respondent 8 is concerned, against her, the title appellate court judgment is there saying that the plaintiff's suit is decreed on ground
Adverse
of adverse
possession
possession.
will relate to the date of
But
appointment.
whatever, what here,
No, you see, we'll see that.
here your
We'll
Lordship
see
will have
that.
to.
Adverse possession will go from the date of
Yes, yes,
filing.
I accept that.
And the estate of the deceased defendant
Yes,
in the original suit, her father,
but I'm
is
trying.
fully represented.
But what I can follow is that your Lordship views that once the father dies, he has 4 legal heirs. All 4 were substituted. One, because of non-substitution, the appeal has abated against one. Therefore, the interest of her father is being represented by other legal heirs. This is what is coming from your Lordship.
Yes.
And therefore, the entire appeal will not abate. Here, not the point is this, that once the appeal, the second appeal has abated against even one of the respondent, substituted respondent also. Then also, not the judgment of title appellate court is confirmed so far as respondent 8 is concerned. Title appellate court says that the plaintiff suit is decreed against all. Now, by virtue of abatement against respondent number 8, the judgment of title appellate court vis-a-vis respondent number 8 is confirmed. Now, if your lordship allows their appeal and holds there was no adverse possession, then lord, there will be two decrees. One by the High Court saying that the plaintiff suit is dismissed on the ground of adverse possession against all these defendants, and there will be one decree of title appellate court on the point of abatement which says that the plaintiff suit is decreed against respondent number 8 on the point of abatement, because it has abated, it has attained finality so far as R8 is concerned.
That's right.
Therefore, I am trying to argue, notes that once it is common, if it can be segregated, the entire appeal will not abate. But once it is common, the interest is flowing from the recorded testimony.
Right. Got it. I have already dictated whatever you have stated.
Note, so far, I would also not draw your lordship's attention to order 41 rule 22 for a moment. Not CBC. Can you lordship?
For what purpose?
But for the purpose of challenging this finding that about my sale deed, saying it is barred by section 46 in violation of section 46. Even though I have not filed any clause objection, but still not order 41 rule 22 gives me the right after 1976 amendment also that you can in an appeal challenge any finding.
This is not a substantial question of
No,
law.
Lord,
Please
this is
don't-
not
please
because
don't
I have
move.
not preferred any appeal.
We don't bother about it.
No, Lord, I can challenge that. That is order 41 rule 22.
No, in spite of the fact that there is no substantial question
No,
of
Lord,
law.
I am challenging a finding
No,
in an
you
appeal.
can challenge a finding in the first appeal, right? We have a specific substantial question of law framed.
Yes.
Hearing has commenced.
Yes.
There is no substantial question of law in connection with if this order 41 rule 22 comes to your rescue to answer the substantial question of law, I can understand. But this is not the
But-
substantial question of
But
law.
I can.
No, the law is absolutely very clear. The court in second appeal will not budge beyond the substantial question of
Yes,
law.
but your lordship.
Please do not try to make out a new point,
No,
a new plea.
but-
Please don't. Please don't.
But-
Your finding that the sale deed was barred by section 46 has attained finality.
No, in my humble submission, it has not, because 41
No, no, we will,
gives me
we will
that
not,
right.
we will not take this.
And that
this
right
kind of,
is
no, you
not at
can't.
the stage of hearing.
You have to take care
Yes,
with respect to the substantial question of law. You answer only the substantial question.
but therefore I say.
You cannot show me one judgment
Yes.
which permits the court to enlarge the scope of substantial
But I
question
am
of
not
law.
saying to enlarging the scope.
What
I
is
am
it
only
then?
saying that I can support the judgment, and if there is a finding against me, order 41 rule
It is
22.
the same thing.
But
It's the same thing.
I am only not trying to argue this.
No,
that
you just
this is
confine
at the stage
yourself
of
to
hearing
substantial. We
only.
will not. No.
But this is the not.
We
this is-
will not permit this in a second appeal where there are specific substantial question of law framed. I have no doubt in my mind that I have to confine myself to the substantial question of law. You being a civil practitioner, please do not digress from the substantial
But I
question
am
of
saying
law.
only this.
In response to any of the substantial question of law, if you have to make this argument, you argue. But not beyond the substantial question of law. That we will not permit. If you do not take steps at appropriate time, we just do not.
But therefore the Honorable Supreme
No,
Court
no,
says-
therefore it can't be like
No,
this.
no, there is a judgment on this, not. there is
Show
a
me
judgment.
that in the second appeal that the court can go. We are in second appeal, no. You
No.
show me in the second appeal, please stick to it. You see, I give patience hearing, but I will not hear what is beyond the
I will not argue
right?
with that. I
Yes.
will not argue. Not 4122, your lordship may see the opening words is upon hearing. So it is at the stage of hearing only.
So what do you want to say upon hearing?
But I say that as a defendant, as a respondent in an appeal, once the appeal is filed and once the appeal is argued at the stage of
You
41,
just tell us what you are referring to order 41 rule 22 in connection with substantial question of law. You just refer to the substantial question of law that in connection with this substantial question of law you are referring to
question
order
number D, your lordship.
D.
Yes.
Okay.
Whether the lower appellate court having held that the sale deed was invalid. So question of sale deed being invalid. This
See, no,
question-
that finding is final.
That's why I say not.
Therefore, the
once-
lower appellate court having held that the sale deed was invalid. then there is a question, could have decreed the suit by holding that the
Exactly.
plaintiff.
So I can support this that the sale deed, whatever finding by the lower appellate court is there, because it is also a question of law, question number D regarding sale deed. So I can support that.
See, the fact that the sale deed is invalid is not the substantial question of law. The substantial question of law is that the sale deed having been held invalid,
Yes.
whether adverse possession could have been
So
decreed.
therefore, not there is a finding by the
So
lower
on the
appellate
legality and validity of the sale deed,
court. Yes.
it is not open to you to advance any argument. The point is that even if the sale deed is held to be invalid, whether adverse possession could have been granted.
But I will answer that also. Not, but your Lordship may kindly bear with me for 2 minutes on this note. Lord,
I give you 2 minutes right now.
but for understand.
No, you see, you have no business to waste the time of the
No, Lord.
You can't waste the time of the court. If you are referring to a substantial question of law, read it correctly. I will not open the Pandora box of holding as to whether the sale deed was invalid or not invalid. I will not advance.
No, Lord,
I will not permit you to advance any arguments
No,
on
Lord,
that.
may see, Lord, there is a finding against me. So far as sale deed is concerned.
Yes,
And
that
the
is final.
question of law. No, that is not final.
That
That is
is
not
final.
final. That in spite of the filing of cross objection, I can argue that the sale deed was valid and the finding is wrong. That is order 41 note 22.
Okay, please take it. Essay number 26. You are taking the dictation by referring to the second substantial question of law number D. The learned counsel for the appellant has submitted that it is still the learned counsel for the respondents has submitted that it is still open to the respondents to argue that the sale deed which has been held to be invalid was actually valid in the eyes of law.
In terms
This
of
court is of the prima facie view that upon correct reading of substantial question of law number D, there is no scope for such argument. In view of the fact that the substantial question of law clearly reads that whether the lower appellate court, having held that the sale deed was invalid, could have decreed the suit by holding that the plaintiff had acquired their right title by adverse possession. The issue is essentially in connection with adverse possession and not in connection with the legality and validity of the finding that the sale deed was valid or invalid.
Lord,
Okay.
can I make submission, Lord?
That's
Because your Lordship is now rejecting
Yes,
my
yes.
submission. Then let me make my submission.
He
Your
has
Lordship will respond,
he has referred to order 41 rule 22 of the CPC to
Yes.
submit that in an appeal it is open to the respondents to assail a finding which has been recorded by the learned court, which is
without filing any cross objection.
without filing any
Yes. And that is not, filing of cross objection is not mandatory. And there is a direct Supreme Court judgment note. I have passed on 99 Supreme Court 3571.
He has referred to the judgment passed by the Honorable Supreme Court reported in bracket 1997 bracket 27 SCC 435. Para number?
Yes. Para 17 to 22. Para 8 onwards, 41-22 have been considered, and then also the Law Commission's report have been considered as to what was the scope, and then ultimately, notes, it was held that in spite of filing cross objection, a finding which is against the defendant can be challenged in an appeal.
Which paragraph? You read it. Which paragraph here? Para 70?
But para 80 से consider होगा 41-22. Start
Para 17 ही पढ़ दी ना?
हाँ 17.
Read it.
Yes. In connection with Order 41 Rule 22 CPC after Amendment 1976, we may first refer to the judgment of Calcutta High Court in so and so, referred in the 54th Report of Law Commission, to the effect that Order 41 Rule 22 gives two distinct rights to the respondent in appeal. The first right to uphold the decree of the court of first instance on any ground which that court decided against him. In that case, the finding can be questioned by the respondent without filing cross objection. The Law Commission had accepted the correctness of the full bench of the Madras High Court. The Commission has also accepted the view of the Calcutta High Court in so and
That's
so.
right. The learned counsel has referred to paragraph 17 of the said judgment, which is quoted as under. This court finds that the judgment passed by the Honorable Supreme Court was arising out of first appeal decided by the High Court, and so far as the present case is concerned, it is at the second appellate stage where specific substantial questions of law have already been framed. This court is of the view that the High Court in the second appellate jurisdiction has to confine itself to the substantial question of law framed, and there is no scope of digressing from the substantial question of law.
Your Lordship also record my submission that at the stage of admission of second appeal, there is no scope of any defendant to argue that there arises another question of law.
इतना आपके डिक्टेशन पे मेरा ऑर्डर नहीं लिखा
मेरा
है।
सबमिशन है।
आपका सबमिशन हो गया, अब आप सब्सटेंशियल क्वेश्चन ऑफ लॉ करें।
One argument was made that so far as the title of the defendant plaintiff are claiming title and simultaneously adverse possession. This cannot be done. Whatever. And they have cited one judgment, 2020 Supreme Court rules.
This guy is 2020. Yes.
Yes.
Before the judgment, you make out a point. What do you have to say?
But I want to make it a point that as a defendant also, I don't dispute this fact that these plea of title and adverse possession are inconsistent. Inconsistent in the sense that a plaintiff or a defendant taking two pleas can't get a decree on both pleas. If one plea is allowed, definitely the second has to be disbelieved, because they are mutually not destructive of each other. If a title is decreed, one cannot say ki grant me a decree on basis of my title also, and one cannot say on the same hand grant me a decree on basis of adverse possession. That is, the court can't grant both the pleas together. Therefore, it is mutually destructive of each other. I say that if in a case where I plead that look here, this is my title document, and in alternative, if the court does not find that document to be valid or legal by any stretch of imagination, then my alternative base second argument would be that I have perfected my title by virtue of adverse possession. This judgment, what has been cited, does not refer to that point. It only says that they are mutually not destructive, or the line is that they are mutually inconsistent.
You were the plaintiff.
I was the plaintiff.
What was your document of title?
Yes. But my two documents.
Did you claim the title on the basis of registered sale deed?
But my two.
Refer to the plaint.
Yes.
Show me that from the plaint you claimed title on the basis of registered document.
Yes.
Like plaint.
Para 9. May I please?
Yes.
That Laldev Chaudhary, further in exercise of his right title, interest and possession, transferred the opposite land measuring an area of 0.11 acres, including the tied house standing thereon by registered deed of absolute sale dated 28/5/28 jointly in favor of Khalku Kalam State and Champalal State and put them in khas possession. So this is my
At the
statement.
end.
Yes. That Khalku Kalam State and Champalal State in exercise of their right title, interest and possession jointly along with their brothers started to surround the aforesaid land by raising compound wall made of stone boulders, sand and earth when the same was objected by the legal heirs of Madhu Kewad, which ended in compromise, whereby it was decided that Laldev Chaudhary shall surrender the land to the settler who shall transfer the same in favor of Ram Chandra Sheth and so and so Sheth and Gulab Chand Seth, sons of Ramchandra Seth, and accordingly by a deed of surrender dated 3/7/28 executed by Laldev Chaudhary on a stamp paper of 8 anna surrendered his right to Meghlab Kewad, who in turn transferred his right title, interest and possession measuring an area of 0.11 acres in favor of Ramchandra Seth on the of so and so Seth and Gulab Chand Seth, son of Ramchandra Seth, on receipt of cash consideration of 45 by executing a sale Sada sale deed on a revenue stamp of 1 anna dated 7/7/28 and allowed the said purchaser, beside Harkuk State and Champalal State, to continue in possession thereof, who accordingly surrounded the same by raising compound wall made stone boulders, earth and sand, and even the same is still in existence, which can be verified by local inspection. So note here, para 9, 10 and 11, it is stated in the plate that Laldev Chaudhary executed a sale deed on 28/5/1928, that is a registered sale deed. After the sale deed, once the right of Laldev Chaudhary stood transferred, Laldev Chaudhary surrendered the land and thereafter notes by virtue of a Sada sale deed, the recorded tenant executed a sale deed in my favor. The Sada sale deed is an unregistered sale deed, not required because it is 45 rupees. And notes this.
Is the plaintiff technically claiming title by virtue of the registered sale deed, or that claiming title by virtue of subsequent development of a compromise and then a Sada sale deed and then a surrender?
Note.
The point why I am asking this question to you, that if the right of the plaintiff is dependent on two distinct transactions,
Yes.
then the plea of adverse possession can coexist with the plea of.
Yes, exactly what this is what I am trying to argue. But I came into possession because para 9 your lordship has seen. I came into possession on 28/5/1928 by virtue of a sale deed executed by Laldev Chaudhary. So that is my point of coming into possession.
And it is this sale deed which has been declared to be
That is
against
7/7/28. 7/7/28 paragraph 10. That is against section 46 it says. That is not the 28/5. One sale deed is of registered sale deed is 28/5/28 from the date when I came into possession, and therefore in para 11 we have said that the point of adverse possession right
the
into
entire
my-
judgment speaks of the fact that the person who had executed the sale deed
Yes,
was not the original Rayer.
yes,
Mool Rayer did not have the right to transfer the property.
yes.
And therefore the subsequent surrender and therefore the subsequent
Subsequent sale.
sale deed had happened.
Yes.
Right? Now, if it stands admitted by the plaintiff that the Dud Rayer did not have the right to execute the sale deed,
Yes.
then the plaintiff himself is disputing the registered sale deed.
Not
And if the plaintiff is disputing the registered sale deed himself and his title is not based on the registered sale deed, then he claims possession by virtue of possession given at the time of registry,
yes.
and therefore he claims possession from 28/5/2028
Yes.
and then says that 12 years has expired.
12 years have expired, and exactly on this note we also see para 11 that the date where I say that 12 years have right is from the date of the first sale deed, that is 28/5/1928. Because there are two deeds notes, one is registered of 5th month, one is unregistered of 7th month. Therefore 12 years we have said in para 11 that it right in 1940 on 27/5/1940, treating my possession to be from the date when the sale deed was executed by Laldev Chaudhary.
Show me the finding where the sale deed has been held to be violative of section 46 is referable to which sale deed?
Yes.
It is not clear from the
Yes, I will
judgment.
show. I will show. Note, we see note, first appellate court judgment note.
Yes.
This is note paragraph 26. And just what should we see? The issue first, because the appellate court is answering the issue. This is a paragraph 12 of the appellate court judgment, internal page 12.
Issue number?
Issue
Point
number
of
4.
determination number?
Sorry?
4.
4.
Who executed this sale
Yes,
deed?
not may I place this?
It was executed by whom?
Whether the sale deed, I am placing issue number 4.
Yes.
Whether
This
the sale
registered sale deed was executed by whom?
It was executed by Laldev Chaudhary.
Okay. All right. Okay.
So, note, this was the issue before the appellate court was whether the sale deed executed by Meghalal Kewat, that is the Sada sale deed, is invalid, having no force in the eye of law. And this has been answered in para 26.
That's right. This has been answered in para 26 and this issue was framed because of the reason that the plaintiff themselves did not claim title by virtue of the earlier sale deed.
Earlier sale deed, because it not
In spite of it being registered.
in spite of it being registered, because not what is there in para 10 and 11, that it is not stated in exact word, but it says that we came in possession on basis of a deed of 28/5/1928, because the word possession is also there in para 9, and put them in khas possession. And therefore in para 11, which is relatable with para 9, that the date of adverse possession expired on 27/5/1940.
एक 4 दिन पहले अभी खुलने के बाद एक जजमेंट किए थे, है ना? एडवर्स पोजीशन भी उसमें था। काउंसिल हमको याद नहीं। हाँ, चेक कर लीजिए।
So therefore, not once
पेज
I
मत दीजिएगा, हमको सॉफ्ट कॉपी दे दीजिए।
once I say that the court, although records a finding that the Sada sale deed is in violation of section 46, then also goes on to decree the suit on the ground that you have perfected your title by virtue of adverse possession, because your lordship will see not both sale deeds are of 1928. One is 5th month, one is 7th month. But the suit is filed in the year 1992. So that is much after the period of 12 years from both the deeds. So notes, to be on this notes that we are claiming adverse possession from 28/5/1928 and we are not claiming adverse possession. So note, we stand on two footings here. One is adverse possession from a different date, that is 28/5/1928, and one by way of Sada Seldi, that is 20.
Sada said it is.
Sada Seldi is not dated 7/7/1928.
What is the finding with respect to the sale deed dated 28/5/28?
No finding. There is no finding by the plaintiff.
Title was declared by the learned trial court.
Yes.
That was reversed by the learned first appellate court.
Yes.
The first appellate court reversed the finding in connection with Sada sale deed.
Sada Seldi.
And the title was declared by the first appellate court with regard to which deed? The Sada sale deed or the registered sale deed?
So title appellate court.
The trial court. You see that appellate court has declared your title, has reversed the finding in connection with Sada sale deed.
Yes.
The trial court declared the title on the basis of Sada sale deed. What is the finding of the trial court with respect to Sada sale deed and with respect to what is the basis for declaration of title by the learned trial court?
Paragraph 14 will make it clear. While issue number 6, 7, 8 were discussed and decided.
आप कुछ नहीं बोलिए प्लीज, आप बैठ जाइए, हम उनसे सवाल पूछ रहे हैं, उनको जवाब दीजिए।
But this is by Sada Seldi. Page 24. Internal page 24, paragraph 13 of the appellate court.
Para number 14.
Para 13.
Para 13.
Page
Please read it.
24. Yes.
Please read it.
Further, it has been contended. Please.
Please.
Further, it has been contended by the learned defense counsel that there is no evidence that the level of possession was given to the plaintiff ancestor or they ever came in physical possession of the land. He has further said that when the transfer is in contravention of provision of law, then the plaintiff will not acquire right of arrival. It has been stated that long possession does not mean adverse possession. It has also been said that Jamabandi creates no title and it is for fiscal purpose. It has also been contended that Khatiyan has not been produced by the plaintiff. The learned defense counsel has cited ruling of so and so, but in my view, the contention of the learned counsel is not tenable and the ruling cited is not fully applicable in this case. In the first place, there is no question of adverse possession because title is passed to the ancestor of the plaintiff by virtue of sale deed executed by ancestor of the defendant. So, ancestor of defendant is the K1, that is Sada sale.
Both is by ancestor of the defendant.
Defendant, ancestor of defendant. So, note, on this ground, the trial court says that adverse possession नहीं हो सकता because title has passed by virtue of a sale deed executed by the ancestor of defendant. That is Sada
Title
sale.
was referable to the Sada sale deed,
Sada sale.
not with respect to the registered sale
Registered
deed
sale.
executed by the Darrayar,
Yes.
somebody
by
called
Laldev
Chaudhary.
Chaudhary. Laldev Chaudhary.
Laldev Chaudhary.
Yes.
And Laldev Chaudhary is not even a party.
Not even a party. Yes.
Right? So they were the title was decided in connection with the sale, Sada sale.
Sada sale.
It was not decided in connection with the earlier
Earlier.
registered
Registered
sale
deed.
because he admittedly did not have the power to execute a registered sale.
And therefore, note,
Just a minute.
Now, notes the judgment which has been referred, 2020 notes.
25.
No, not to by the other appellate notes.
We refer the judgment, please also. दो हजार बीस का
Sir,
हाँ बुक दिए थे जजमेंट दिए
हाँ बुक दिए थे वही
बुक दिए
but I just want to
बुक का
yeah
का वापस कर दिए क्या बुक नहीं होगा AIR से
AIR
SCC SCC नहीं था AIR 2020 SC
but equivalent citation उसका 2020 volume 15 SCC 218 वही
2020 volume
15 SCC 218 this is Narasamma versus A Krishnappa dead to this was the judgment
किताब कहाँ चला जाता है आप लोग का कंटिन्यूटी में केस सुन रहे फिर भी किताब नहीं है यहाँ पे What do you want to say?
yes but I want to say this that the Supreme Court here was considering a case where the plaintiff has filed a suit for declaration and not the defendant is taking a plea of title and adverse possession for defending. This was the fact. Initially the suit was dismissed. The appellate court not allowed and Supreme Court confirmed. But the suit was dismissed on the ground, saying that defendant is in continuous possession and therefore the plaintiff cannot seek title. Plaintiff was coming from the branch of recorded tenant. Defendant says that we have an agreement to sell and therefore we came into possession and therefore they claim adverse possession. In that situation, Lord, the suit was decreed by the appellate court saying that the document on which the defendant is trying to base his claim of adverse possession, I would like to, can I pass on my copy? Because all the documents, the court disbelieves that document, says.
You see, the point is
Yes,
that in order to claim adverse possession, you have to acknowledge the title of the respondent,
yes,
other side. Right?
yes.
When you claim a property by virtue of a registered sale deed or a sale deed, then at that point of time you do not acknowledge the title of the other side. Once you do not acknowledge the title of the other side, then under such circumstances, what is the date on which the title became adverse?
But once I acknowledge the title of the defendant,
The law is very well settled that you cannot have the same. This plea is absolutely conflicting.
is conflicting. I say definitely conflicting because no court can grant a decree on title and also on adverse possession. Therefore, they are conflicting. But there is no bar. I am saying that there is no bar in making an alternative plea. The Lordship may kindly
You
appreciate
can make
this.
alternative what you can make 100 pleas. But
Yes.
the point is that the law is well settled that such conflicting pleas cannot
Yes.
be entertained.
But it does not say that it cannot be entertained.
This is the judgment says.
No, Your Lordship may kindly see the judgment itself. Even the Supreme Court holds that we have, I am just placing para 21(8), we have already observed as aforesaid that the plea of original defendant, that is wife of Nasama, possessed title was not established on the basis of documents sought to be propounded. It is relevant that none of the parties choose to implead her as party. Once the case of original defendant was that Srimati Nasamma who had derived title, the alternative plea was of her adverse possession. Then to establish that plea, at least she ought to have been examined. Therefore, the court is not debarring me that I cannot take this plea. The court only says that if you are taking an alternative plea of adverse possession vis-a-vis title, it is not that it is not permissible in law. It is permissible in law. The court only says that both cannot go together. A court can't grant decree together of both. Because these, if one is granted, the other will fail. If other is granted, the first will fail. Both can't go together. But I can take is one. But I can't take. That means there is a bar that I cannot take the plea. That is not the judgment. Even I have a judgment note which says that even an invalid or an illegal transfer by which I was claiming title, even if that transfer goes on any ground, then I can take a plea of adverse possession. I will cite that also. Yes. So, what I am trying to argue here is on that their judgment is that the court does not bar me on this. The court only says that these pleas are inconsistent to each other. Alternatively, I can take this plea. There is no bar in this judgment as such. Because the Lordship is aware before this, in the Garewal case 2012, the defendant could have taken the plea of alternative also. After that judgment, it came that as a plaintiff also you can take that judgment, defense or plea for proving your title. So now let me assume that if in a case here, as such, I take two pleas of title and adverse possession, I can take that plea, but in both pleas I cannot get a decree. This is what the court says, because they both can't go together. There is no bar in taking that plea. My submission is this.
On the point of inconsistent plea of adverse possession and title, the learned counsel for the respondents has referred to the judgment cited by the appellant, which is reported in AIR 2020 SC 4178, equivalent is bracket 2020 bracket 15 SCC 218, and has referred to paragraph 28 of the SCC report and submits that.
But this is a Supreme Court. I have a Supreme Court. SCC would not be.
पैराग्राफ 28 को हम क्या बोलना?
But Supreme Court.
क्योंकि सब में पैराग्राफ नंबर चेंज होता है ना.
But I will pass on this copy also.
दूसरा कॉपी नहीं है.
हमको लगा कॉपी ये इसलिए मुझे अपना
कॉपी वो कहाँ दिए?
I'm sorry madam, it's a mark लिखी होगा तुम्हारा.
To submit that there is no legal bar in taking both the plea of adverse possession as well as title. But what has been held is that the court cannot decree the suit on adverse possession as well as on title with respect to the same.
Not so. This your Lordship will see
The
one.
learned counsel has also submitted that the plea of adverse possession has been taken with respect to the registered sale deed dated 28/5/1928 by stating that 12 years completed on 27/5/1940, and he submits that the plea of adverse possession is not referable to the Sada sale deed, which was executed on
But 7/7/28.
7/7/1928.
But SCC is para 29.
पैरा
29.
पैरा 29 SCC का पैरा 29 और यहीं पे कोट कर देंगे. ठीक है, ठीक, आगे बढ़ते हैं.
one argument was made that if the document is held, not, I am claiming a document of deed and I cannot claim adverse possession. Then notes on that the Lordship will see notes one judgment which says that even if a document is held to be invalid or illegal, then from that date also I can take a plea of adverse possession. This is 1970 Supreme Court, but it refers to 51 Supreme Court, which is a 5-judge bench. This is 1973 SCC, page 802.
Parent?
Yes. But the Lordship will straight away come to note para number 16. There is no material placed before us to show that the grant has been made in the manner required by law. Though as a fact, a grant of the site has been made in favor of the institute. The evidence relied by the Special Land Acquisition Judge and the High Court also clearly establishes that the respondent has been in open, continuous and uninterrupted possession and enjoyment of the site for over 60 years. In this aspect, material document evidence referred by the High Court clearly establishes that the respondent has been treated as owner of the site and not only corporation but also the government. The possession of the respondent must have been on the basis of a grant made by the government, which no doubt is invalid in law. As to what exactly is the legal effect of such possession has been considered by this court in Collector of Bombay versus Municipal Corporation, City of Bombay, 1952 SCR, equivalent is 51 Supreme Court, 469. As follows: the position of the respondent corporation and its predecessor in title was that a person having no legal title but nevertheless holding possession of a land under the color of an invalid grant of the land in perpetuity for free from rent for the purpose of a market, such possession not being referable to any legal title, it was prima facie adverse to the legal title of the government as owner of the land from the very moment the predecessor in interest of the respondent corporation took possession of the land under the invalid grant. The possession has continued openly as a right of uninterruptedly for 70 years, and the respondent corporation has acquired a limited title to it, and its predecessor in interest had been prescribing during all this period, that is to say the right to hold in perpetuity free from rent but for the purpose of market in terms of government rules. That establishes that a person in such possession clearly acquires title by adverse possession. In this case before us, there are concurrent findings. So not here the Supreme Court finds that refers to a situation where a person in possession by virtue of a document which is invalid in law, then that date also can be considered for treating adverse possession, and adverse possession would be granted.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1970 bracket 3 SCC 802 State of West Bengal versus the Dalhousie Institute Society, and has referred to paragraph 16 of the same judgment to submit that if a person is in possession of an invalid, it has been held that the party was in possession of an invalid grant, but and was also treated as an owner not only by the corporation but also the government. The continuous possession of more than 60 years amounted to adverse possession.
So here, even we not say this, that even if the sale deed is held to be valid, violation of section 46, invalid because of any law prohibiting, then
Otherwise also Sada sale deed.
but Sada sale deed, because there is no requirement of registration, source initiation. It is 45.
45
It is 45. So Sada sale deed, but it is.
That's right.
So even if it is in violation of section 46, what has been held, Lordship has said, I can't challenge that finding. I agree, Lordship, let us assume this to be final. Then, Lords, even this date also 12 years could be counted, and therefore the decree of adverse possession is absolutely correct. Because the law provides that. The only argument was that I am claiming title and simultaneously I am claiming adverse possession. These two can't go together, and therefore the judgment is bad. There is no bar as such. What I want.
That's all. Yes, appellant, you have to say anything?
So far as the issue of amendment is concerned, which there is only one reply to that. That so far as the decree, in the event the appeal succeeds, then there please that in the event the appeal succeeds, there will be two decrees. One decree would be that which the appeal abates against respondent number 8, meaning thereby there is a decree so far as the disease respondent number 8 is concerned, so far as on the point of adverse possession. And if the appeal succeeds, the adverse possession, the claim of adverse possession will go. So it will not amount to separate. It will not amount to be a. We can say that it will not be a joint decree. It will not be a indivisible decree. In any event, it will be a separable and divisible decree. In that event also. That is one reply to that logic so far as the abatement is concerned.
Ratanlal Jain was the plaintiff.
Yes.
All of them were defendants.
Defendants. And
The appellant before us is the co-defendant.
yes, co-defendant.
Right? Appellant before us is the co-defendant. So, if the adverse possession of Ratanlal Jain is set aside,
Yes.
then under such circumstances, the defendants will be entitled to exercise their right, title, interest, or whatever they have.
There will be no decree because they do not suffer any decree.
Because
The right which has been crystallized or which has been granted by the court, that will go.
that will go.
That will go. Simply that will
So
go.
this will not be a severable decree.
Yes, therefore the issue of abatement will not have any impact so far as the present appeal is concerned. And even
Because
otherwise,
because the appellants and the deceased respondent,
they were
they
all,
were all on the same boat.
yes,
And if the appeal is even allowed, they will not suffer any
yes, that what I
in any manner.
yes, that
And the estate stands fully represented.
that was submitted on behalf of the appellant. Therefore, yesterday also on this plea. And alternatively, which has also come from the side of the honorable court, that even otherwise, since she has left behind the other legal heirs who are already parties to the proceedings, therefore also there will be the abatement will have no impact. There will be no conflicting. There is no question of any conflicting decree, which is the only analogy to find out whether the abatement will have any impact if there is conflicting decree. That is one part.
In response, the learned counsel for the appellant has submitted that the plaintiff was Ratanlal Jain, and altogether there were 12 defendants in the suit. The learned first appellate court and declared adverse possession in favor of Ratanlal Jain, and only some of the defendants are the appellants before this court, and the remaining are practically the pro forma defendants. He submits that the respondent number 8 who has expired is only a pro forma defendant. The learned counsel submits that if the appeal succeeds, then the adverse possession of Ratanlal Jain will be set aside, and the appellants and the pro forma defendants would stand on the same footing. He submits that in such circumstances, there is no question of any conflict in preparation of decree by this court. He has further submitted that the original defendant number 5 was Ram Prasad Kevat, and upon his death during the pendency of the suit, he was substituted by his wife and minor son and 2 minor daughters. He submits that the estate of deceased respondent number 8 is fully represented. Or are you?
And so far as the issue of adverse possession, on the issue of adverse possession, the argument advanced by them, especially with reference to this state of West Bengal versus Vivid Dalhousie Institute Society, which has also been considered by the learned First Appellate Court. Here, this case, the factual matrix was totally different. There was a grant by the state government, and the dispute cropped up when the land was sought to be acquired and compensation was sought to be disbursed. And that grant, issuance of that grant was found to be admitted. In such circumstances, that is preceding para 15, in such circumstances, the findings have been recorded. In that sense, the issuance of the grant was admitted, and therefore, on virtue of that grant, they continued. So
and that grant was invalid.
That grant was invalid, but issuance was admitted.
Here also.
Yes.
The execution of the Sada deed is also admitted. But it became
that we have not admitted.
No, this is the finding. The only reason for setting it aside is that it was violative of section 46.
It is finding, and
That
our
is
written
the
statement we have never admitted. We have said that no,
might not have, but the finding of the court is that it was invalid only because of this.
section 46. Therefore, factual aspect we could distinguish.
You just tell us one thing. They never claimed title. They claimed title by virtue of Sada deed, and they claimed adverse possession from the date of the registered deed.
Yes.
And that registered deed was invalid. They are conscious of the fact that it is an invalid deed. That is why it was succeeded by a Sada deed.
Yes.
Right? So therefore, their right of claiming adverse possession is with the date of the registered deed, and they claim title with respect to the Sada deed. So they are two different cause of action for claiming adverse possession and for claiming title over the property.
Yes.
Then, under such circumstances, such kind of inconsistent plea is permissible or not permissible?
It is not permissible because what has been argued by them with reference to the Narasimha case. It has never been held in that case. What has been argued? It has been held that such pleas.
तभी ना second appeal है. नहीं तो क्या चीज़ के लिए second appeal? If everything is already decided.
Yes, yes. Then I am
तो
just
second appeal में क्या करेंगे हम लोग?
I am just referring to para 32 and thereafter.
Which paragraph did you rely upon?
Yes.
क्योंकि वो उसमें AIR वाला छप गया. बताइए तो कौन सा paragraph होगा?
Yes. Para 32 onwards. Para 32 onwards.
आप देखिए. Once the case of the original defendant was that it is Srimati Narsimha who had 29, who had derived title. An alternative plea was of her adverse possession. Then to establish that plea, at least she ought to have been examined. ये तो उसमें है, ठीक है. Which says that inconsistent plea cannot be taken. Paragraph number बताइए.
Then 30 and 31. 30 because you may also note that on the one hand, the appellant said in have sought to take a plea of violation vis-a-vis the original defendant, claiming that position came to them in 1976 with the suit being filed in 1989. Yet, at the same time, it is claimed that the wife had title on the basis of these very documents.
On the basis of these very documents.
Very documents.
They are not claiming title on the basis of. They are not claiming adverse possession on the basis of which they claim title. They claim title on the basis of Sada sale deed. They claimed adverse possession on the basis of registered sale deed. So these two are two distinct documents altogether. Their claim is not arising out of the same documents.
And for that purpose, the logic behind that is that so far as one of the requirement, paragraph 30 and then 31. I'm just placing 30 as the fact. Yet at the same time, it is claimed that wife had title on the basis of this very document. The claim of title from 1976 and the plea of adverse possession from 76 cannot simultaneously hold. On the failure to establish the plea of title, it was necessary to prove as to from which date the possession of the wife of the defendant amount to a hostile possession in a peaceful, open, and continuous manner. We fail to appreciate how, on the one hand, the appellant claimed that wife of the original defendant, appellant number 1, had title to the property in 1976, but on their failure to establish in the alternative the plea of the adverse possession should be recognized from the very date.
From very date.
Yeah.
You see, the claim was from the same date. Here the claim is from a different date.
And then 31, where reference has been made to the basic ingredients of adverse possession, which has a link with the issue. Para 31 with reference to Ravindra Kumar Girewal. We also find that reliance placed by the 11th Council is also discussed. The question which arose for consideration before the Honorable Three Judge whether suit could be maintained for declaration of title for confirmed defendant seeking such and such, or that it was an instrument to file defense. In fact, Para 31 from the 6th line onwards. In fact, if one may say, there was for a long time a consistent view of the court that the plea could only be seen and not assured. The judgment changed his legal position by opining that a plea to retain possession could be managed by the ripening of title by way of order of person. However, to construe such adverse position,
You see, there is no point phrase with respect to this.
These three requirements has to be satisfied for this purpose.
No.
And
That is not the question of law. Please don't digress from the
no,
question.
for the purpose of adverse position.
Your question of law is whether simultaneously these plea could be taken.
And whether it has been decided in right perspective, the issue of not
Right,
adverse
you have argued on right
Yes.
perspective.
Now
Don't
what?
expand your arguments in the rejoinder.
No, I'm not. I'm just showing that nec precario. That is one of the requirement. Adverse to a competitor in denial of title and his knowledge. So this thing has never been there. In adverse to a competitor in denial of title and his knowledge. So there is no denial of title. There is no such pleading. Rather, there is admission of title. So that is one of the requirement of adverse possession, basic requirement, and which has a link. Therefore, it is linked with this mutually exclusive case. And this thing is missing. Therefore, so far as the issue number 2, question of law number 2 is concerned, that decision of that issue number 8 on its right perspective, that has perhaps not been considered in its right perspective because this is missing. It is one of the basic requirement to plead and prove that they have perfected title by the prescription of adverse possession with help of Article 65 of Limitation Act. And this is not there in denial of title. This thing is not there. It has never been considered. And until unless these three requirements are satisfied, there cannot be a decree on basis of this prescription of adverse possession. because from 27,940 they cannot set up a plea because they themselves then again say that cell deed. It comes after that date. That registered cell deed is prior date, and then comes that Sada cell deed. So there is no continuity. That Sada cell deed breaks. So that requirements are not there, which has not been considered. That is true that they have taken one cause of action showing the registered cell deed. But in between comes the Sada cell deed, on basis of which they claim it. So the continuity breaks. It is not there. The basic requirement of adverse possession. One is denial of title, another is continuity. None of these are satisfied by the plaintiffs and not properly considered.
Learned counsel for the appellant has again referred to the judgment passed by the Honorable Supreme Court reported in bracket 2020, bracket 15 SCC 218. And has submitted that all the basic ingredients to claim adverse possession, that is nec v, nec clam, and nec precario, has not been satisfied in the present case. He submits that though the plaintiff claimed to be in possession by virtue of registered sale deed executed by the Rayat but by virtue of execution of subsequent sale deed by the Rayat, they claimed title. And therefore there is no continuity of possession of the plaintiff. In such circumstances, the basic elements of adverse possession is not satisfied. In spite of the fact that the Sada sale deed was held to be invalid on account of absence of permission from the Deputy Commissioner under Section 46 of the Jharkhand Tenancy Act. Was this ever the plea?
46. Yes, that was in our written statement.
Sure.
Paragraph 17 of our written statement at page 12. Page 12, the last sentence of paragraph 17, the alleged sale deed executed by the name of Mengal Kaur is contravention of section 46 of the Jharkhand Tenancy Act.
This was introduced by way of amendment.
Yes. It is part of the pleadings. Whereas with reference to para 16 to 18 of the written statement, we said that the factual matrix in the case of the Lousy case 1970 is different from our case.
Yes,
Because
the
there is
Learned
not-
Counsel has also tried to distinguish the judgment passed by the Honorable Supreme Court reported in bracket 1970 bracket 3 SCC 802 and has submitted that the said judgment was on a different context. The proceeding was arising out of a land acquisition case, and at the time of grant of compensation, it was found that the claimant was in possession of the property by virtue of an invalid grant by the government. And considering the long possession of the claimant, it was held that he had adverse possession, he had perfected his title by way of adverse possession. He had acquired title by way of adverse possession.
And that there the issuance of grant which distinguishes was found to be there from the official records. That grant was issued.
Invalid grant though issued by the government.
Yes. Yes.
That's all.
Yes.
Just two things. But same judgment notes, just दो चीजें दिखा रहे हैं. But पाला 33.
आप एक चीज कितना मिस कर रहे हैं. आपका एक सब्स्टिट्यूशन पेंडिंग है जिसमें आज कोई बहस नहीं. I will dismiss it as not pressed. आपको तो होश ही नहीं रहता है.
इम्प्लीमेंट वाला वो जो परसों की जो बात हो रहा था जिसमें हम लाना चाह रहे थे शांति देवी. Since our their IA was considered and our IA was not considered, was disallowed. Therefore, there is no point in pressing that IA.
Substitution of respondent number 12. I will dismiss it as not pressed. I will just dismiss it as not pressed.
उसको press कर दो.
नहीं कैसे प्रेस करेंगे आप? How? You have wasted 2 days of the court and you want to press substitution now? आपसे पूछते हैं तो भी आपको नहीं पता है. लिस्ट में दिखता है पेंडिंग है तो भी आपको नहीं पता है. How irresponsible you are?
We have missed it. Respond number 12.
Missed it means what? You need a reminder from the court. चेक करिए आप अपना. खुद ही नहीं पता है.
नहीं, that is IA 9426 of 2022. IA 9426 of 2022.
वो तो हम ऐसे ही नहीं अलाउ करेंगे. उसमें तो फॉल्स एफिडेविट. ऐसे ही हम डिस्कस कर लेंगे उसको. उसका भी अवेटमेंट का सेम प्ली होगा जो इसका है. After the conclusion of the arguments, it has been pointed out by the court to the learned counsel for the appellant that one IA number, बताइए.
9426 of 22.
9426 of 22 seeking substitution of respondent number 12 is pending before this court. The learned counsel has submitted that he could not press this interlocutory application. No, the learned counsel was clueless about the pendency of this interlocutory application, but upon perusal of records, he found that the same is pending. In the interlocutory application, it has been mentioned that respondent number 12 died on 8/7/1995 during the pendency of title appeal number 15 of 1995. Record दिखाइए. ये The records of the case further reveals that on 7/9/2022, the counsel for the appellant had prayed for time to address this court as to whether the judgment and decree of the appeal, which is impugned in the second appeal, having been passed against a dead person, and if the decree is a nullity, and whether the second appeal would be maintainable. The records of the first appellate court reveals that the wakalatnama on behalf of Cheto Kevat, right,
Yes.
was executed on 2/12/1995. And was accepted on 22/12/1995. लीजिए, दिखाइए। Cheto Kevat, LTI, right? Meaning thereby that he was certainly alive on the date of execution of the wakalatnama. And the statement made in the interlocutory application appears to be incorrect. This court is not at all satisfied with the आप ही की गोतियां है ना? Yes? It is further not in dispute that the respondent number 12 and the appellants were co-defendants and belonging to the same family. In such circumstances, this court is not inclined to. This court is of the considered view that neither the date of death has been correctly disclosed, nor the delay in filing the interlocutory application has been explained. And accordingly, this court is not inclined to allow the interlocutory application, which is hereby dismissed. एक और आई है, addition of party. इसको भी dismiss कर देते हैं. That is formal.
That we are not pressing because since
Other IA number which is pending before this court is dismissed as not pressed. At this, both the counsels have advanced their arguments on the point of abatement, and they adopt the same arguments as has been advanced in connection with deceased respondent number 8. इसके अलावा कुछ बोलना है?
Only one thing. वो नरसम्मा वाला केस नंबर SCC का citation paragraph 33 तो लॉर्डशिप will see Karnataka बोर्ड ऑफ वक्फ जिसमें केस रेफर किया हुआ है, there also the court does not say, it only says that the sorry, paragraph paragraph 33 the Lord I am placing वही paragraph का last से bottom से दो the plea of title and adverse possession are mutually inconsistent, absolutely correct, and the latter does not begin to operate under the former is renounced. So the court does not say you cannot take plea. It is a right not which, and therefore a bar or a stoppel has to be not by a creature of statute or by a law. There is no law by any judgment or statute which says that you are not allowed, you cannot take this plea. Both every court says that they are mutually inconsistent, but there is no bar as such in taking the alternative. And so far as an argument was made that a registered sale deed is the date when we came into possession, and therefore there was no continuity because there was a Sada sale deed also. But there is no one's case that I was dispossessed and then we again came in possession in the 7th month by executing a Sada sale deed. So therefore the possession was all throughout from the date of a registered sale deed, that is 28/5/1928. So it can't be said if by executing a Sada sale deed we were not in possession, continuity of possession, there is a break in continuity. Because there is no WS saying that
The learned counsel for the respondents has additionally submitted that the possession of the plaintiff was pursuant to the registered sale deed, and while in possession, a Sada sale deed was also executed. He has submitted that there was no discontinuity in possession of the plaintiff. Okay? Khatam?
pending 9/05/2022
9/55 of 22. ये क्या है?
सब्स्टिट्यूशन के लिए
किसका सब्स्टिट्यूशन?
मॉडल नंबर 13596
वो पेंडिंग है?
ये pending तो शो कर रहा है। छपा है।
9/3
9/555
9/55. Ratanlal Jain has expired. Respond number 1. Mr. Banerjee, I don't have words to express. I really don't have words to express.
No, this is something which has better call than this.
You are taken by surprise?
There's no surprise. In fact, we should have verified the records
Yes.
before starting the argument. That is omission on our part that we did not verify the records.
ये दिख रहा है लिस्ट में, और कैसे वेरिफिकेशन करेंगे आप? Has he expired?
Yes.
आप भी बहस कर रहे हैं, आपके क्लाइंट पीछे बैठे हैं. They are your clients?
Yes.
They are also not concerned. You are also not concerned. एक का 2001 में डेथ हो गया है, तो 2012 में डेथ हो गया है.
But post legal का notice गया है. That I see वकालतनामा, my वकालतनामा is there on behalf of son of Ratan Lal. 7/7/2022 was the वकालतनामा. उसमें नोटिस नहीं होगा हमको लगता है.
नोटिस हो गया है.
अच्छा.
नोटिस हो गया है. क्या ये नंबर क्या बताया हमको?
9,555.
9,555 is pending.
Yes, sir. 9,555.
But what I see that we have filed
Notices have been served.
but what I see that we have filed an application under order 2210A informing about death of Ratan Lal Jain, and we have appeared by filing wakalatnama in terms of 2210. This is of 2022.
बाकी लोग को तो notice served है, all the legal years and successors have been served. They all have been served. अब बताइए मिस्टर बैनर्जी, क्या किया जाए आपका?
आइए 955 of 2022 is concerned, in respect of the respond number 1, 13 and 135 and 6, since the notices were found by the order number 24 to be validly served, to that extent that IA will be considered. Because 8 already order has been passed. Order number 24 dated 10/6/2024.
आइए नंबर 555 है ना,
Yes.
आपका सब्स्टिट्यूशन अलाउ कर देते हैं, इनका अलाउ कर देते हैं, वकालतनामा आपने फाइल किया है। आइए 555
955.
और 22 है ना।
Yes.
वो सीक्वेंस में नहीं
But
था।
can you pass on the copy?
9426 Another IA being IA number 9555 of 22 has been pointed out by the learned counsel for the appellant. Whereby a player was made seeking substitution of respond number 1, 3, 5 and 6. Counsel for the respondent has submitted that he has already filed wakalatnama on behalf of the legal heirs and successors of respond number 1.
Along with order 22 rule 10.
Along with order 22 rule 10,
10A petition.
10A petition. He has no objection so far as the prayer for substitution of respond number 1 is concerned. Where have you stated that you had no knowledge about the death?
Para 5 is that there is no such specific that para 5 is like
There is
this.
no statement that you
No,
had
it
no
is not.
knowledge.
That made inquiry about the particulars, that in course of inquiry 6 is there.
But there is no statement that you had no knowledge.
Could collect the information regarding the above.
They are your family members. The learned counsel for the respondents has objected to the
Except
prayer for
respondent number
substitution. Yes. With respect to the prayer for substitution of respondent number 2, 3, 5 and 6 and has submitted that they belong to the family of the appellants and there is no averment in the interlocutory application that the appellant had no knowledge about the death of these respondents, who are said to have expired on 13/7/99, 1/1/2001, 17/4/2012. With respect to respondent number 3,
5 and 6.
5 and 6 respectively.
Address is also same, given in the affidavit and the details of legal bills.
He also submits that even the address given in the affidavit
Affidavit of
accompanied with the interlocutory application and the details of the legal years is also the same.
the address is same.
पक्का है ना?
हाँ. Village PO Saran, Bhumiya district Bokaro. Same affidavit.
Considering the aforesaid objection raised by the learned counsel for the respondent, this court is of the view that there is even the date of knowledge has not been mentioned in the interlocutory application, and the delay is not satisfied. Accordingly, this court is not inclined to allow the petition for substitution of respondent number 2, 3, 5 and 6.
So 3,
It was prayer also.
Sorry.
3, 5 and 6.
3, 5 and 6. 2 का तो ऑलरेडी डेथ हो चुका है. 2 का तो कुछ फाइल नहीं किया है ना. 2 has also expired.
2 is also expired. Because 7/9/22 order records about the abatement of the appeal, which includes 2 also. 2 and 7 also.
नहीं 2 and 7 का they are already on record. 2 and 7 के बारे में कुछ नहीं बोलना. Expand हुआ था 2 and 7. ठीक है? चलो. वो रिजेक्ट हो गया आपका. So far as the point of abatement is concerned, same arguments have been advanced. Correct? What else?
So
हो गया. एक आइए you don't want to press. So और एक कौन सा आइए?
This IE only to the extent of respondent number 1.
हाँ. Respondent number 1. 1 is allowed.
Now,
Respondent number 1 is allowed.
तो जिसको कर
एक और आइए है.
एक आई जो जिसमें करना है इसका
एडिशन ऑफ पार्टी. वो कौन सा?
ये है 8808 of 2024.
8808 of 24 is dismissed as not pressed.
yes.
IA number 8808 of 2024 in connection with addition of party is dismissed as not pressed.
But only one submission on this floor. That so far as वो सुमित्रा वाला था 8, the lordship has said कि उसका interest was being represented. Here lord, respondent number 3 is Gurumal Kewat. He is arrayed as defendant number 1. So lord, his substitution is rejected. So lord, his interest is not being represented. Similarly, respondent number 5 here, Shyamlal Kewat, he is defendant number 3 in the plate. So not same argument for 3 and 5 that their interest is not being represented by anyone.
But they are pro forma respondents.
Pro forma respondent, yes,
They are pro forma.
Yes, they are pro forma respondents.
The learned counsel for the respondents has also submitted that. So far as respondent number
About respondent number 3 and 5 here,
3 and 5,
where defendant number 1 and 3 in the plaint.
who were defendant number
3 and 1 and 3
1 and 3 in the
in the
plaint.
plaint.
The proceeding has abated against them also, and their interest is not being represented. इसको आप नाम डिलीट कर दीजिए रिस्पॉन्ड नंबर 1 का, क्योंकि वो जजमेंट में फिर दिक्कत हो जाएगी. अब ये सबका कैलेंडर
ठीक है.
पोस्ट फॉर जजमेंट ऑन 27th Jan. टाइम लगेगा आपको. ये जो खिचड़ी बनाए ना आप लोगों ने, यू हैव सच गुड जूनियर्स, क्या करते हैं लोग? दूसरा केस में बिजी रहते हैं. सेकेंड अपील में यू शुड हैव अ, फॉर एवरी केस यू शुड हैव अ डेडिकेटेड जूनियर.
There can be no excuse for these reasons or lapses. Any reason will be not suffice. These are procedural part. It is
नहीं, you see,
whatever it may be.
a case can be, a judgment can be set aside on account of these procedural lapses.
Yes, definitely.
Then
In a given case, it gives rise to other side. May not
Yes.
be in this case, but in a given case, it
like,
can
we
be
do
this.
not know what will happen in this case, but it is absolutely unnecessary. चलिए 98 का केस में आप लोग बहस करिए, इसी के लिए बहुत बड़ी बात.
But now this case is over, but your lordship is, whenever your lordship is have time, वो CNT Act का जो manual है उसमें flag लगा दिए. But how the law has evolved so far as this CNT Act is concerned. But so many amendments in 46 have gone to so many changes in this.
From subpoena list and reading for orders, item 1, second appeal, 88 of 1984.
Also, there is one for substitution of the respondent also. IA number 14039.
आपको सप्लीमेंट्री फाइल किया करना था, क्या किए? कुछ नहीं किया.
Yes. वो तो सब्स्टिट्यूशन इसका है. डिले कंडोनेशन.
रिस्पोंडेंट नंबर को आपको एरर ठीक करना था, क्या किया? आप बोल रहे थे कि कंफ्यूजन है, किसका आप चेक कर लिया?
चेक कर दिया.
बताइए किसका
पैरा 9
रिस्पोंडेंट.
में लॉर्डशिप देखा जाओ.
पैरा 9 नहीं बताइए,
पैरा 9.
पहले हमको बताइए किसका डेथ हुआ, किसका सब्स्टिट्यूशन आप ब्रेक कर रहे हैं, नाम बताइए. नाम बताइए किसका सब्स्टिट्यूशन आप ब्रेक कर रहे हैं.
1A नामिया देवी. नामिया देवी died leaving behind his 3 years. नामिया देवी.
When did she die?
Died 2009. Died in year 2009.
2009. During pregnancy.
And there are 3 years.
Just a moment. When did you come to know about her death? Where have you mentioned? When did you come to know about her death?
After substitution of the appellate proxy, then they have come to know.
When did the appellant die? When did the original appellant die?
Substitution after
कब डेथ हुआ था ओरिजिनल अपीलेंट का?
13 नहीं, इसमें हुआ क्या लॉर्ड? सब्स्टिट्यूशन के बाद हमें पता किया तब पता चला है आफ्टर
उसका काम
2025
अपीलेंट का डेथ कब हुआ था ये बताइए।
इससे जो हम लॉर्ड 3 जनवरी 2020
हाँ
2013 लॉर्ड 2013
3/1/2013 को अपीलेंट का डेथ हुआ।
लॉर्ड
तब तक तो अवेट कर दिया था प्रोसीडिंग। बाय दैट टाइम द अपील हैड ऑलरेडी अवेट 2009 में, उसके बाद 2013। तो इसीलिए ये आप उनको मत बताइए कि अपीलेंट के डेथ के बाद आप यहाँ पे सब्स्टिट्यूशन फाइल कर रहे हैं, एंड देयरफॉर द डिले।
पता ही नहीं था सेकंड अपील के
कहाँ लिखे हैं कि आपको नहीं पता था, या आपके जो इतना लाइटली आप सब सब्स्टिट्यूशन हम अलाउ ही नहीं करेंगे। इट कांट बी टेकन सो लाइटली। टेल अस।
ये जो ऑर्डर शीट आया लॉर्ड 7/10/2009 उसी वक्त सारा कुछ आ गया था उसमें।
उस वक्त आप ये सब बात बताए ही नहीं कि इतना लोगों का डेथ भी हो गया। कहाँ बताए थे? उसके बाद फाइल किए हैं सब। पढ़िए, अपना पिटीशन पढ़िए। ऐसे नहीं हम अलाउ करेंगे आपका सब्स्टिट्यूशन। यू रीड योर पिटीशन।
उतना क्लियरली तो कुछ
नहीं है तो क्लियरली तो अवेट करिए।
सप्लीमेंट्री
नहीं, सप्लीमेंट्री क्या है? इसका सप्लीमेंट्री का कोई स्कोप ही नहीं।
supplementary petition of the University. The very pendency of the second appeal responded for 1A. Namia the appellant said submits that substituted appellants have failed to got information regarding the year of death of respondent for 5, 6. Actually, then they have
नामिया देवी का डेट ऑफ डेथ बताइए।
year है नामिया देवी का 2009।
कहाँ लिखा? कहाँ लिखा?
हाँ सप्लीमेंट्री आइए केस नंबर 3 लो।
सप्लीमेंट्री आइए।
हाँ आइए और सप्लीमेंट्री पारा 3 लो। पारा 3 रिप्रेजेंटेशन सेक्रेटरी रेस्पोंडेंट नंबर 1 नामिया देवी डाइड इन ईयर 2009। Respondent number 1 Opia Devi died in year 2003. Likewise, respondent number 3 Bukar Mia died in year 2017. Respondent number 4 Abdul Karim died in year 1958.
So, what is the date of knowledge?
और अदर का पता नहीं चलता।
अदर मतलब ये कौन अदर? किसका पता नहीं चल पाया?
5, 6 and 8 years. Para 5 will cover it. There are 3 appellants say as submit that it is duty of the advocate of the citizen.
फाइव, 6 and 8 का डेथ कब रिकॉर्ड हुआ था ऑर्डर शीट में?
और सिर्फ नहीं आया।
ऑर्डर शीट में आया?
लास्ट ऑर्डर शीट है 10 फरवरी 1998 राधी अंकुर मिस्टर जस्टिस लोकनाथ प्रसाद
किसका किसका पता नहीं चला। रिस्पॉन्ड नंबर 5, 6 and 8 नाम बताइए।
फाइव में महावीर होगा 6 में है गुनु
आपका ये कॉस्ट टाइटल जो हम लोग बनाए हैं उससे टैली नहीं करता।
हाँ ये तो एक्सटेंड हो गया ना इसलिए सीरियल ये तो ये 2 जो था 1 हो गया हाँ वो टैली नहीं करता और 8 जो था वो अबेट हो गया वो 7th में आ गया
8 इज छोटू महतो ये अबेट हो गया।
वो 8 में था वो 7th हो गया इसीलिए टैली
नहीं वो 8 में नहीं था।
नहीं हमारा ये सीएमपी में
सीएमपी का कॉस्ट टाइटल हम लोग बनाए हैं ना।
हाँ सीएमपी से ही बनाए थे
एक फाउंडेशन महतो इनका वेट हुआ है।
नहीं छोटू
जिन लोगों का डेथ हुआ है 3/1/2013 के पहले और ओरिजिनल अपीलान ने उसके अगेंस्ट में कोई स्टेप नहीं लिया उसका हम सब्स्टिट्यूशन अलाउ नहीं करेंगे क्योंकि अपीलान हैज डाइड ऑन 3/1/2013। जिसका जिसका प्रोसीडिंग उसके पहले अबेट कर गया है उसका हम सब्स्टिट्यूशन अलाउ नहीं करेंगे। We will not allow that. Not possible. There is no explanation for delay. Not at all. ये जो आप बोले हैं ना कि आप बाद में आके आपको पता चलेगा, this is not correct.
ये तो डिसमिस सब कुछ पड़ा हुआ था आफ्टर रेस्टोरेशन
डिसमिस कब हुआ?
ये सीएमपी अपील सुप्रीम कोर्ट से फिर ऑर्डर हुआ
डिसमिस कब हुआ?
डिसमिस ना ये सीएमपी जो पहले ये तो रेस्टोरेशन फॉर्म में है।
डिसमिस कब हुआ? अपील तो पूरा कभी डिसमिस हुआ ही नहीं।
नहीं,
तो फिर
बिल्डिंग का।
फिर क्या कर रहे थे? What were you doing? The appeal was never dismissed.
No.
Then
नहीं, dismiss against the head.
कोई बात नहीं। अब बाकी का क्या कर रहे थे?
बाकी को मालूम नहीं।
पार्टी को क्या नहीं मालूम? आपको तो मालूम था ना केस जिंदा है। The case was never dismissed. The case was never dismissed. कौन सा आईए नंबर आप बोल रहे हैं?
1403.
IA number 14039 of 25 has been filed, seeking substitution of respondent number 1 within bracket A, Namia Devi, is said to have expired in the year 2009. One within bracket B, and further substitution of respondent number two, Lakhan Lal, who is said to have expired लखन लाल का डेट ऑफ डेथ, लखन लाल का डेट ऑफ डेथ बताइए। नहीं लिखा है ना? Whose date of death has not been disclosed. Semicolon, substitution of Bukan Mia, respondent number 3, who is said to have expired in the year 2017, semicolon. Substitution of कौन है? Abdul Karim, within bracket, respondent number 4, who is said to have expired on
19.
Sorry,
1988.
in the year 1988, substitution of responding number, इसके बाद और कौन responding number 5 Mahabir Mehto, whose date of death has not been disclosed. Semicolon, substitution of respondent number 6 Agnu Mehto, whose date of death has not been disclosed. अब्दुल करीम के बाद एक सेकंड, महावीर महतो लिखे हैं, उसके बाद अग्नु महतो लिखे हैं, उसके बाद रिस्पॉन्ड नंबर 7, अच्छा रिस्पॉन्ड नंबर 8 who is said to have expired on, whose date of death has also not been disclosed. So far as Chotu Mehto is concerned, the proceeding has already abated. नहीं, abatement respond number 8 के against होगा, फाल्गुनेश्वर मेहतो के against होगा, छोटू मेहतो के against होगा। रेस्टोरेशन किसके फाइल किए थे? एक सेकंड,
CMP से लिखा जाता है, CMP नंबर 337/2015,
अबे किसके अगेंस्ट होगा?
इसी इंपॉर्टेंट पोजीशन में
इसका एक चार्ट था ना, कहाँ है इसका चार्ट? चार्ट बना के दिया था इसका?
स्टार्टर्स में पहले
Respondent number 8, Falgunation method. Falgunation method का respondent number 8.
यहाँ कोई
कहाँ से बोल रहे हैं कि Falgunation method respondent number 8?
छोटू छोटू
टाइटल
छोटू
सूट से क्यों देख रहे हैं आप? ये हम ये फर्स्ट टाइटल बना है, इससे देखिए ना.
हाँ इसमें
इसमें respondent number 8 तो Falgunation method. Falgunation method है टाइटल.
छोटू मतलब कोई लीगल या तो है नहीं.
अब कहाँ से बोल रहे हैं respondent number 8 was Falgunation method? From where are you saying this? And from where are you saying that the proceeding has abated only against Falgunation method? No. The proceeding has already abated as against respondent number 8, Falgunation method. The records of the case reveal that during the course of the argument, the counsel for the appellant has submitted that there is a delay of 9,855 days in filing the petition for substitution. He has further submitted that the sole appellant Bhakti Mehto had expired on 3/1/2013. And the substitution has been allowed by the order dated 7/10/2025. The second appeal was dismissed as against respondent number 8. Has abated as against respondent number 8. And thereafter, the legal and the explanation furnished is that legal heirs had no knowledge about the pendency of the second appeal. This court finds that the Nomia Devi, as per the interlocutory application read with the supplementary affidavit, Nomia Devi died in the year 2009. खोखिया देवी died in the year 2003. खोखिया देवी बोल के तो कोई है ही नहीं इसमें. Kokhiya Devi died in the year 2003 and Abdul Karim died in the year 1988. The appellant had expired only on 3/1/2013, but till his death no steps were taken for substitution, and the proceedings against them had already abated. The explanation furnished by the appellant with respect to delay in filing the petition for substitution is not acceptable. At least with respect to Nomia Devi, Kokhiya Devi, and Rukun Mia, and Abdul Karim. The petition seeking substitution of the legal heirs and successors is dismissed with respect to them, and the proceeding stands abated. So far as they are concerned. At this, the learned counsel for the appellant has submitted that let notice be issued to the other legal heirs and successors with respect to the other respondents who have expired. However, before proceeding further, it is important to decide as to whether the appeal has abated as a whole. नहीं तो notice करके भी करो. If the appeal has abated as a whole on account of the aforesaid facts and circumstances. Accordingly, the counsel for the appellant is directed to address this court as to whether the appeal would at all survive. बहस करिए, अबेटमेंट पर बहस करिए. जब तक हम सेटिस्फाइड नहीं होंगे तब तक लीगल होल्डियर्स को क्यों नोटिस करें? बताइए क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ बना?
Order 19, order dated 7/10/2025. Order number 19.
पैरा 19 में नहीं, इसमें ओरिजिनली क्या बना था सब्सटेंशियल क्वेश्चन ऑफ लॉ?
ये सॉर्ट में है तब ये
बताइए व्हाट इज द सब्सटेंशियल क्वेश्चन ऑफ लॉ?
whether the suit in the present court or declaration is having any question related to the adverse position as claimed from the side of defendant numbers 1 and 2. Second, whether the plaintiff's suit would suffer due to his non-filing of declaration against the defendant number 1 and 2 challenging the.
कहाँ से पढ़ रहे हैं आप सब्सटेंशियल?
ये ऑर्डर डेटेड लॉ से कोई प्रीवियस ऑर्डर डेटेड है.
डेट बताइए ना, कहाँ है सब्सटेंशियल क्वेश्चन ऑफ लॉ? नोटिस करते समय सब्सटेंशियल क्वेश्चन ऑफ लॉ बना होगा ना?
ये डेट है 8/7/1996.
8/7/96.
At the time of the admission.
हाँ बताइए 8/7/96.
इसी में सेकंड पेज. The second appeal is admitted on the following substantial question of law. First में है whether the suit in the present court for declaration is having any question related to the adverse position as claimed from the side of defendant number 1 and 2. Second है whether the plaintiff suit would suffer.
Who was claiming it? Who are you? You are the plaintiff or the defendant? You are the plaintiff?
Lord, first plaintiff, then respondent. And
You are the original plaintiff.
Lord.
Who claimed adverse possession? Who claimed adverse possession?
Defendant Lord.
The defendant claimed adverse possession. Now, many of the defendants have expired,
Lord.
right?
And they have also sold out.
They have also sold out. Then, under such circumstances, the entire appeal would abate. बताइए क्या बचेगा इस अपील में? आधे लोग मर गए. रिस्पोंडेंट नंबर 9 ये फाल्गुनेश्वर महतो कौन थी? What was his role?
Purchaser है वो.
He was purchaser, no?
Lord.
Then under such circumstances, the entire appeal would abate. Purchaser from whom?
ये defendant.
From defendants?
Lord.
Then the entire appeal will abate. आप ही बताइए फाल्गुनेश्वर महतो के एब्सेंस में आपको क्या रिलीफ दे सकते हैं? नो रिलीफ. नहीं, आप हमको बताइए. It's not that I am absolutely open to your arguments. You just tell us what relief can be granted to you in absence of the purchaser of the property, against in connection with which the appeal stands dismissed. बताइए बताइए हम आपको क्या रिलीफ दे सकते हैं? हाँ ठीक है.
After contest notice.
वो चार्ट कंटेस्ट क्यों करेंगे? जब प्रोसीडिंग ही अबेट कर गया तो हम किसको सुनेंगे और किस लिए सुनेंगे? There is no point. There is no point. In order to argue as to whether the appeal stands abated as a whole, the learned counsel submits that the matter will be posted to. कल बहस कर लीजिए, कल डिसाइड. इतना आपको टाइम दे सकते. इसके beyond
कल नहीं पड़ेगा।
नहीं हो पाएगा तो मत करिए ना.
मंडे
इतना लंबा टाइम होने दो.
मंडे कल
आज ही करना था आपको. कुछ बचा नहीं है इसमें. The purchaser of the property के अगेंस्ट में अबेट कर दिया प्रोसीडिंग. Matter ends. That's the end of the matter.
मंडे कर दिया जाए, पता कर सकते हैं क्या बचा है।
अब क्या बचा है? किससे पता करना है?
जो लीगल एयर ऑफ द रिस्पोंडेंट,
किसका रिस्पॉन्डेंट?
लीगल एयर ऑफ द रिस्पोंडेंट,
कौन सा रिस्पॉन्डेंट? भाई 8 के अगेंस्ट में अबेट कर गया, ठीक है? तो आप हमको बस इतना ही बता दीजिए अपील में क्या बचा है आफ्टर अबेटमेंट. बचा है परचेजर के अगेंस्ट में अबेट कर गया है. हाँ, ऑफ कोर्स. Respondent number 8 was the purchaser. The appeal has abated against respondent number 8. आप तो थे कोर्ट में. Respondent number 8 के अगेंस्ट में अबेट किया है प्रोसीडिंग.
ये जो 1 and 2 सब ये कंटेस्टिंग पार्टी हैं लोग।
कंटेस्टिंग से क्या होगा? जब प्रॉपर्टी बिक गया तो थर्ड पार्टी राइट क्रिएट हो गया ना.
टोटल प्रॉपर्टी नहीं होता है।
I do not know. You are the plaintiff. The defendant was claiming adverse possession. The adverse possession was declared.
And in the appeal,
In the first appeal. Adverse possession was declared. Now many of the defendants have expired. तो उसको हम कैसे set aside करें? बताइए. How do we set aside that order of claim of adverse possession which has already been declared in favor of the defendants? And some of them have expired.
ये मंडे कर दिए देख सकते हैं क्या कोई जजमेंट देख सकते हैं।
ठीक है, मंडे को कर लीजिए.
हाँ
4 बजे सुनेंगे हम आपको. पूरा दिन नहीं वेस्ट कर सकते आप इसे. At 4 o'clock. आप कौन है इसमें? रिस्पोंडेंट है?
आइटम